eventually price them out. We have fucking technology and forced to adjust, right? But so if we have some people will be like, yeah, force them to do it. We're probably starting to that's a bad thing.
I see a lot of names that I see on briefs. I guess we haven't seen
Hello, we're going to get started with our program. If everyone could quiet down. All right. Thank you all. Sounds like very lively conversation everyone's having. Well, welcome. On behalf of the Madison Lawyers Chapter of the Federalist Society, I'd like to welcome everyone here today for our event featuring Hans von Spakovsky of the Heritage Foundation. My name is Heather Berlinski, and I'm the president of the Madison Chapter of the Federalist Society. The Federalist Society was founded on three principles. First, that the state exists to preserve freedom. Second, that the separation of governmental powers is central to our Constitution. And third, that the role of the judiciary is to say what the law is, not what the law should be. The Society seeks to promote an awareness of these three principles through engaging in events such as today's event. Before I introduce Mr. von Spakovsky, I'd like to take a moment to recognize some distinguished guests in the audience here today. Waukesha County Circuit Court Judge Maria Lazar. Newly appointed Court of Appeals Judge Brian Hagedorn. And the Assembly Campaign and Elections Chair, Representative Kathy Bernier. Today, we are pleased to host Mr. Hans von Spakovsky to discuss recent developments on political speech and campaign finance laws. Mr. von Spakovsky is a senior legal fellow at the Heritage Foundation and manages the foundation's election law reform initiative. Prior to his work at the Heritage Foundation, Mr. von Spakovsky was a commissioner for the Federal Election Commission, where he was responsible for enforcing federal campaign finance laws for all congressional and presidential elections. He also served as counsel to the Assistant Attorney General for Civil Rights, providing expertise and advice on voting and election issues. Hans von Spakovsky concentrates his legal writing expertise on voting, elections, campaign finance, civil rights, immigration enforcement, the First Amendment, and government reform. His published articles have appeared in many areas such as the Wall Street Journal, the Washington Times, National Review Online, and many other news outlets. In 2012, along with John Fund, he co-authored the book Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk. And recently, he released his second book in conjunction with John Fund, entitled Obama's Enforcer, Eric Holder's Justice Department. He does have copies of both those books at the registration table, and I'm sure he'd be able to sign those if you would like to pick up a copy on your way out. With that, let me introduce Mr. von Spakovsky.
All right, well, it is nice to come someplace where they have normal names like Berlinski. Since I grew up in a neighborhood in Alabama where everybody was named Smith and Jones, except for me. I actually teach a course as an adjunct at George Mason Law School on election law, and Heather asked me to basically give you the entire semester class in 1 hour. So you all are fortunate you're not going to get a final exam. But she asked me to talk about the First Amendment and campaign finance law, and that is certainly been an important issue in this state recently with the John Doe investigation, which fortunately your state Supreme Court finally ended. And I'm going to talk about that a little bit at the end. But she asked me to give you kind of a primer on this because this is really an important issue right now. You know, the First Amendment is a pretty simple statement that guarantees some very fundamental rights. And there's a reason it's the First Amendment in the Bill of Rights, because it's so important. And, you know, just to remind you, it says, Congress shall make no law abridging the freedom of speech or the press or the right of the people peaceably to assemble, to petition the government for redress of grievances. Now, I left out the part about religious freedom, also very important, particularly today. But that provision is being violated all over the country, and there's a push to violate it all over the country by state legislatures, by members of Congress, and frankly by the media, which benefits by this but wants to see it restricted in the election area. And you know, how bad is it? It's so bad that in September of last year, the United States Senate voted on a Senate resolution to amend the First Amendment. Every single Democratic senator voted in favor of it. I think it's the first time in our history that we had that kind of a vote to pull back on rights within the Bill of Rights and within the First Amendment. And what that amendment would have done is it would have given Congress the power not just to limit the amount of money raised and spent by candidates, but it also would have been given them the power to limit the amount of money spent and raised by anyone else that, quote, supports or opposes candidates. Now, that is such a broad phrase that it would have meant virtually that there would be no limit on the power of Congress. Now, all of this election campaign reform business goes back about 100 years. That's when this all first started, when Congress passed the first federal campaign finance reform bill. And I like to cite this. Liberals and others who support campaign restrictions don't like me talking about this because they point back to this 1907 law as just being wonderful, a great example of Congress trying to reform our campaigns. But I like to talk about it because it actually proves something that I think is self-evident if you look at the last 100 years of history on this, which is inevitably when people come up and say they want to reform our campaign finance laws, there's inevitably this ulterior motive to hurt the other side of the political aisle. And the first law passed in 1907 is a great example of this. As all of you know, in federal elections, corporations cannot make direct contributions to candidates for president or for Congress. Well, that's because the Tillman Act was passed in 1907, which for the first time kept corporations from being able to contribute directly to federal campaigns. Now, the reason it's called the Tillman Act is because the sponsor of it was Ben Pitchfork Tillman. Okay, he was a United States Senator from South Carolina. He'd been the governor of South Carolina, and he was probably one of the worst racists to ever serve in the United States Senate. He was responsible almost single-handedly for bringing back, implementing Jim Crow laws after the end of Reconstruction. He was involved in a very infamous massacre of federal militia forces, mostly black South Carolinians in South Carolina. And he was such a racist that Teddy Roosevelt barred him from coming into the White House. Now, why in the world would Ben Pitchfork Tillman be interested in cleaning up our campaign finance system and preventing corporations from contributing? Well, in the 1904 presidential election, when Teddy Roosevelt came in, there were all these stories about large business corporations, particularly in the Northeast, giving a lot of money to the Republicans and particularly to Teddy Roosevelt. Teddy Roosevelt was rumored to have gotten $500,000 alone from the New York Life Insurance Company, which in 1907 dollars, that's a lot of money. Teddy Roosevelt was embarrassed because, as you know, he ran as a reformer. The reason Tillman wanted to end this was because, remember, 1907, the Democratic Party was what? They were the party of segregation and Jim Crow. And business corporations did not give them money. Segregation and Jim Crow cost companies money. The railroad companies, it cost them money to have separate train cars and all the kind of things they had to make do in the South. So they gave their money to Republicans. And Ben Pitchfork Tillman thought that the public outcry about the corporate money going to the Republicans would be a great opportunity to use the so-called ticket of reform to do what? Hurt his opponents, the Republican Party, by cutting off money to them. So that was the basis of the Tillman Act. Now, for about every 25, 30 years after that, there would be some scandal, and Congress would pass another piece of legislation. For example, after the Teapot Dome scandal in the 1920s, Congress passed the Federal Corrupt Practices Act. That, for the first time, required national party committees to file reports of their expenditures. In 1939, 1940, Congress passed a bill because he said it was a violation of the First Amendment. The Supreme Court never actually ruled on that provision, although it's really interesting. That's the provision that the Supreme Court tossed out
in the Citizens United decision. Now, I'm sure you all have seen all the reports in the New York Times saying, oh, those terrible conservatives, right? Terrible conservatives acting in a horrible way to throw out that provision. Well, in 1947, it was a Democratic president saying it was a horrible violation of the First Amendment. The Supreme Court never ruled on the constitutionality of that provision until Citizens United, but that ban actually came up before them in two other cases, once in 1948, once in 1957. In both cases, the court avoided the constitutional issue and threw out the cases on statutory grounds, saying that the statute didn't actually apply to the facts in the case. But in both of those cases, some of the liberal stalwarts of the court, people that liberals think were some of the greatest justices of the Supreme Court, like Earl Warren, all in their dissent said, this provision is unconstitutional and we should have thrown it out because it violates the First Amendment. Now, the other big thing that finally happened in 1971 that brought us to where we are today was in 1971, Congress passed the Federal Election Campaign Act. That basically consolidated all these prior laws, put in new ones, and then in 1974, after the Watergate scandal, I always like to say, one of the things of the Watergate scandal was they found all kinds of cash that was kept in the safe of the Nixon campaign. And, do you all remember what the re-election campaign of the president, what its name was, what his acronym was? CREEP. Whoever came, the Committee to Re-elect the President, whoever came up with that, not very smart. But what that law did in 71 and 74 was it put in, for the first time, the limits on how much you could contribute to a federal candidate, $1,000. It put in aggregate limits, saying you couldn't contribute in total more than $25,000. They also established a federal agency, the Federal Election Commission, to actually do civil enforcement of this law the way the GAB does civil enforcement in the state. Now, they left criminal enforcement to the Department of Justice. And if you knowingly violate these federal campaign finance laws, you not only can pay a civil penalty, you can go to jail, which to me is a very problematic issue in an area that's so affected by the First Amendment. These campaign finance laws, all these reformers said, we're supposed to clean up our system, right? Well, do you know what the biggest result was of these campaign finance laws, particularly the limits put on how much you could contribute? The biggest result of it was the incumbency re-election rate shot up. And there's a good reason for that. These kind of limits on how much money you can actually contribute, so how much a candidate can ask you for, what does it do? It hurts challengers. An incumbent has a known name, they have a position that makes people interested in giving them money. If you're a challenger, you want to knock off an incumbent, it's a lot harder to raise money. And that's why, when these laws were passed, and a lawsuit was filed against them called Buckley versus Vallejo. This is the seminal case on campaign finance law. A bunch of folks got together, they sued and said all these new provisions, particularly the limits on how much you could contribute to a candidate, it was unconstitutional. One of the people who was involved in that lawsuit was a very well-known liberal Democrat named Eugene McCarthy. He sued, and the reason he sued was because he said, look, remember, why was Eugene McCarthy famous, right? In 1968, what did he do? He challenged an incumbent Democratic president, Lyndon Baines Johnson. And he did so well in that election that Johnson withdrew from the race. And McCarthy was one of the people suing against these new restrictions. Why? Because he said, look, if this law had been in place when I tried to challenge the incumbent president, I couldn't have done it. Why? Because the way he got his campaign started was he had a couple of close friends who liked him and believed in what he was trying to do, and they gave him each large contributions, enough money to basically kickstart his campaign and get it going. And under these kind of restrictions, he said he wouldn't have been able to do it. Now, the Buckley versus Vallejo decision is the one in which the court came up with its test that it uses to say, and this you see this all over. This is the test they use to say whether a campaign finance rule is constitutional or not. And that is, will it prevent corruption or the appearance of corruption? And in using that rule, the court said, well, having a $1,000 limit on how much you can give to a candidate, that fits the bill. That prevents corruption or the appearance of corruption because nobody's going to sell their office for $1,000. But Congress didn't just put in a contribution limitation. They also put in an expenditure limitation. They actually put a provision into the law that said that people running for president and for Congress couldn't spend more than a particular amount. Now, you all know how much we spend today on the presidential race, right? In the last race, I think Barack Obama spent about $750 million, right? The limit that Congress put in back in '71 that would have been the total amount that anybody running for president could have spent would have been $10 million for the primary and $20 million for a general election. Now, the U.S. Supreme Court threw out, they upheld the contribution limitation. They said that doesn't violate the First Amendment. And the reason they said it didn't violate the First Amendment was because you may be limiting how much money you can get from one particular candidate, but you're not limiting how much money you can raise. And therefore, you're not limiting that candidate's speech. And the court recognized money equals speech. But they threw out the expenditure limitation because they said, if you're saying that a candidate can only spend a certain amount of money, you are violating their First Amendment rights because you are violating their ability to speak. Now, I constantly debate so-called reformers in Washington and elsewhere who say money doesn't equal speech. Well, that's ridiculous. You can go back to the American Revolution, okay? And what was one of the fundamental works that helped inspire the American colonists to throw off the yoke of the English crown and fight the revolution? It was Thomas Paine's Common Sense, right? Well, it cost money to print and publish that. It cost money to print the broadsheets on which the Federalist Papers were printed to try to persuade people to ratify this radical new Constitution. The days when you could stand on a soapbox in the Boston Common if you wanted to run for Congress and try to convince people to vote for you are long gone. And if you limit the amount of money somebody can spend on their election, you are limiting their speech. Because everything from campaign brochures to setting up a website to buying airtime, all of that costs money. So when you're restricting the amount of money that a candidate can raise and spend, you are restricting their First Amendment rights. And the court threw out a limit on the expenditure. Now, interestingly enough, Congress in '71, oh, by the way, one of the other things the court threw out, can you imagine this, giving this kind of power to a federal agency? I served on the FEC as a commissioner for 2 years. And the extent of our power was if we found that a candidate or political party was violating the federal campaign finance laws, we could impose a civil penalty on them. They would have to pay. Congress originally gave the FEC the power to disqualify them from the ballot. And fortunately for us, the Supreme Court threw that out. Thank goodness. The other thing, by the way, that Congress did that the court also threw out was they put in a $1,000, remember, 1947, Taft-Hartley, right? Congress had said no corporation or union can spend any money on an independent political expenditure. Well, Congress put in a new provision in '71, which the Supreme Court threw out, in which they said nobody, not just corporations and unions, but no one, including any individual, could spend more than $1,000 in an independent political expenditure. Can you imagine that? That would mean that if you wanted to spend $5,000 of your own money, somebody was running for Congress in your district, and I'll give you a good example of this. what was his name? The guy in Louisiana who was the former Ku Klux Klansman, Dukes? Right, David Dukes. I actually know, I have a good friend who was in Louisiana at the time. He's actually then went to work in Washington. He was one of the editorial people on the Washington Times. He was so upset by Dukes running for Congress that he organized and got a bunch of his friends together. And they spent their own money to try to defeat this guy. Well, under this law that Congress had passed, that would have been illegal. That could have landed them in jail for doing that, for spending their own money to try to defeat a candidate. And fortunately, the Supreme Court threw that out. So what does that bring us to? That brings us to the Citizens United decision, which is so hated by the New York Times and the Washington Post and everybody else that, if you'll recall, that decision was issued in the beginning of January of 2010. And what did the president do in his State of the Union address? He criticized the court with the justices sitting right in front of him. And one of the things he said in that law was they overturned 100 years of precedent. Okay, well, that is an absolute lie. I mean, that is just completely wrong. But what was the Citizens United decision about? I think a lot of people lose kind of track of what it was about. Citizens United is a small nonprofit advocacy organization in Washington. Most of the money they get are from individual contributors. They get some corporate money. And in 2008, when Hillary Clinton was running for president, boy, something familiar about that. They decided to make a documentary about Hillary Clinton. It was called Hillary the Movie. Now, Citizens United is a pretty conservative organization, so as you can imagine, the documentary was not very favorable to her. And what they did was they went out and they interviewed people who knew her and talked about her, and they basically talked about why they didn't like her and why she didn't have a good character and had bad. It was a very negative piece. But I'll tell you, if you watch this, this was not that different than some of the documentaries I've seen on places like HBO that they do about people like Ronald Reagan. Now, nowhere in that entire documentary, did they ever say you should vote for or against Hillary Clinton. But when they wanted to try to advertise that movie, they couldn't do it. You know why? Well, y'all remember the McCain-Feingold law? That was the last major piece of reform that was passed. Feingold, somebody that people in Wisconsin should be familiar with, right? And John McCain, in 2000, so they passed the McCain-Feingold law. The formal name was the Bipartisan Campaign Reform Act. That put in even more restrictions. And one of the other restrictions it put in is it tried to make that ban on independent political expenditures even tighter. And they put in a provision that said, if you're a corporation or a union, you cannot run an ad on radio, TV, or cable within 30 days of a primary or 60 days of a general election that mentions the name of a federal candidate. Now, if you think about that for a moment, you'll realize that that completely interferes with the ability of corporations and unions, including nonprofit corporations, because it didn't just apply to for-profit corporations, to engage in, what, grassroots lobbying of Congress. Because, for example, if you look at the votes in Congress, you'll notice that the frequency of votes goes up as you get closer to an election. You know, they want to have a vote they can brag about in the upcoming election. But what this provision meant was that if you were a union and Congress was about to vote on a union-busting bill of some kind that you as a union didn't like, and you wanted to run an ad that said, call Senator Smith and Senator Jones and tell them to vote against this bill. Well, if you did that within 60 days of the November election, you were violating federal law. And the FEC said to Citizens United, you can't run an ad for this movie. If you run an ad for this movie, you are violating federal law. And if you do it knowing that it's a violation of federal law, you can go to prison for advertising a documentary movie about Hillary Clinton. Now, the New York Times and the Washington Post, they just love this provision because, of course, Congress isn't stupid. And what did they do when they passed this electioneering communications ban is what it's called? Well, they put in an exception for media corporations. So if General Electric, which I think used to own MSNBC but doesn't anymore, if they wanted to run an ad, right before the election criticizing a candidate or telling people not to vote for that candidate or just mentioning a bill of some kind, they could do it. But other companies couldn't do it. It was a big exception for media corporations. I found it kind of funny that after the Citizens United decision, the Washington Post ran this big editorial complaining about corporations using, I think it was the word they used was their deep pockets, their deep wealth, to try to influence American elections. They, of course, didn't mention that the Washington Post company has like $5 billion in assets, and what do they do every election? They try to influence the election with their editorial page. But it's okay if they do it, just nobody else. Now, there's been all this criticism heaped on Citizens United, and the one I love the best are those who say corporations aren't persons. They don't have a free speech right. I don't recall that being made an issue back in the mid-1960s when the New York Times company was sued over the Pentagon Papers, and the premier case on the fact that newspapers have First Amendment rights is called New York Times v. Sullivan. It's not New York Times v. Sullivan. It's actually New York Times Company v. Sullivan, in which the Supreme Court applied the First Amendment to the New York Times Corporation. Nobody there said, well, they're a corporation. They don't have any First Amendment rights. I often ask people who say that to me, I say, okay, so you don't think any part of the Bill of Rights applies to corporations? And their immediate answer is, well, of course not. I said, okay, well, that means that you believe that if the United States government, which is having a bit of a money problem at the moment, if they decided that they wanted to nationalize Google, which is now a huge corporation, it's worth a lot of money. If they want to nationalize Google and not have to pay the owners of Google any money, you believe they can do it because you don't believe the Fifth Amendment, which requires the government to pay you fair market value if they exercise eminent domain over something you own. You don't believe the Fifth Amendment applies, right? And they kind of get taken aback by that. Or I say, obviously you believe that if the government thinks that General Motors is doing something wrong, they can just show up with the FBI and a SWAT team at General Motors and seize all their records, their computers, everything. They don't actually have to go to a judge and get a search warrant and establish that they've got probable cause because you don't believe the Fourth Amendment applies to them. I mean, that's why that is such a short looking opinion. So sorry, a short view. The key thing about this prohibition was that it applied to nonprofits, corporations also. So that meant that an advocacy organization, if they were incorporated, could not engage in independent political expenditures. They couldn't engage in what's called electioneering communications. And that really violated their First Amendment rights in their entirety. There was actually a very telling moment during the oral argument. There were two oral arguments in that case that were held. I was at both of them. And the first oral argument was a very telling moment. Remember, the electioneering communications ban that the court threw out, remember, that's the one that says you can't do a radio or TV ad within 30 days or 60 days of an election that mentions a federal candidate. So Chief Justice Roberts asked the Assistant Deputy Solicitor of the United States, he said, he posed a hypothetical. What if a corporation or a union wrote and published a 500-page book that discusses the American political system, and at the end, on the very last page, it says, because of everything we've just said in this book, you should, in the next election, go out and vote for X. And the Chief Justice said to the United States Department of Justice, if Congress wants to amend that electioneering communications provision and extend it beyond radio ads and TV to books and pamphlets, could Congress do that? And showing the danger of, if you're a lawyer answering a hypothetical question in court, Mr. Stewart, the Assistant Solicitor General, says, yes, we could prohibit the publication of a book. Now, just think for just a moment what the representative of the United States government had just told the Supreme Court. They just said that Congress had the power to ban books in this country. The Chief Justice pointed out after that the government was urging the Supreme Court to embrace a view of the First Amendment that would, quote, allow censorship not only of television and radio broadcasts, but of pamphlets, posters, the Internet, and virtually any other medium that corporations and unions might find useful in expressing their views on matters of public concern. Under that view of the power of the federal government, there wouldn't be anything that would prevent Congress from prohibiting newspaper editorials that oppose or support a particular candidate for office. And as the 5-4 majority pointed out, the government does not have the power to decide who gets to speak and what they get to say. Justice Scalia has a great quote from him, which I got to give. He says, quote, a documentary film critical of a potential presidential candidate is core political speech, and its nature as such does not change simply because it was funded by a corporation. To exclude or impede corporate speech is to muzzle the principal agents of the modern free economy. We should celebrate rather than condemn the addition of this speech to the public debate. Now, I happen to think the more public debate we have, the better. The more political speech we have, the better. Unfortunately, the reformers, again, I use that word with quotes around, the reformers I always talk to who want even more campaign restrictions, their answer to speech they don't like is they want to restrict it. They want the government to censor it. And I could tell you, I just can't think of anything that would be worse than that. In fact, when I was on the FEC for 2 years, this was before the Supreme Court tossed out this particular provision. So I, as a commissioner who was sitting there, had sworn to uphold the Constitution and the laws of the United States, I was put in this terrible position as a commissioner of trying to decide whether particular advertisements, political ads, which is political speech, violated federal law or not, and whether we could ban them and go after the people doing it. That was, to me, it was just horrible to put a government bureaucrat in that position. And I can tell you that of the commissioners that I served with, and this is kind of a general observation, the FEC was made up of 6 commissioners, 3 Republicans, 3 Democrats. And we would sometimes be at loggerheads over this because we couldn't decide, come to an agreement on whether something violated the law or not. And yet we were expecting ordinary people, ordinary candidates, to be able to comply with a law where we disagreed on what it meant. And the way those votes broke down, it always came down along the same lines. My view, and the view of my fellow Republican commissioners always was, if the law is ambiguous, then the government loses and the public wins. Whereas my colleagues, all of whom were very nice people, I respected them, we disagreed on policy often, but their view always was, well, if the law is ambiguous and gray, the government wins. And that really was the dividing line between the way we did this. Now, I'll tell you, what happened to Citizens United and the fact that David Vossi, the president of Citizens United, could have been sent to jail for making a political documentary is not as bad as what I have seen sitting in Washington happening in Wisconsin. the judges on the GAB here, the district attorneys who worked in here, worked on this, pushing this John Doe investigation. I mean, I frankly was appalled at what was going on. Look, I was a commissioner at the federal agency that did this. Yeah, we investigated all kinds of cases. You know, anyone can file a complaint with the Federal Election Commission claiming there's been a violation of federal law, and the commissioners would decide whether this investigation needed to be opened. But how did we do investigations? Well, we did it the way you do any other civil case. You know, you take depositions, you get records, the other side gets a lawyer. If they want to complain in public about what you're doing, they have a right to do that. The idea that we would have authorized the FBI to show up in the middle of the night with a SWAT team to serve a search warrant on some head of a political action committee or an advocacy group at their personal home where their family's living, I just find that appalling. And such an abuse of power. It would never have occurred to us to do something like that. We would never have authorized anything like that, and yet that's what's happened here. And it's very clear that the officials here do not understand the difference between direct participation in a campaign and issue advocacy. You know, there are federal rules against coordination. What coordination means is when you are directly helping a candidate get elected. And the coordination, that's illegal under federal law. You know, if a candidate comes to you and says, look, I'd really like your organization to run an ad that says you should vote for me in the upcoming election, that's illegal. And yeah, the government has a right to regulate that, because otherwise you're getting around the contribution limits. But if legislators are getting together with people on issues, that is a fundamental First Amendment right. And in fact, you should want that to happen. You should want the public to be engaged with their legislators working on issues that are on their way through the legislature, working on public policy problems. And yet, the people at the GAB here and others involved in this obviously didn't understand that. And I think the state ought to be embarrassed that it has a law on the books that allows these John Doe investigations, which are essentially the same as a general warrant. Now, for those of you who know your legal history, our Fourth Amendment was specifically designed to prevent general warrants. General warrants were used by the English king. You know, they would decide they didn't like a particular individual, and would have no evidence that the person had actually violated the king's law or anything else. But with a general warrant, they could basically go in and search everywhere and everything that person owned. And there is a great deal of discussion, you can find it in the late 1700s, about how these kind of general warrants violated basic rights, the basic rights of Englishmen. And the writers of the Constitution were well aware of this. They had, in fact, had that same problem with crown officers in the colonies, and they wanted to prevent it. And yet that is exactly, that kind of a general warrant process, that is exactly what this John Doe investigation seemed like, and what the law authorized. You know, what's even worse is that the prosecutors are unapologetic about this. I mean, I've seen the latest stories about this, and I have to say, I think the special prosecutor that was hired, I'm embarrassed to say, I think used to work at the U.S. Justice Department, where I also worked, but I understand he was in charge of doing terrorism prosecutions there. He seems to have brought the same mindset to the area of elections and the First Amendment. And I have to say, even worse is, again, from what I've read and what I understand, is you have staff members of the GAB who broke the law in starting an investigation before they'd even gotten authorization to do that. Now, I can tell you the Federal Election Commission has very similar rules. When a complaint is filed with the FEC, the staff cannot open an investigation until and unless the commissioners have voted to open an investigation. And they can only do that and authorize that if the commissioners on the record say that there is a reason to believe that a federal campaign finance law has been violated. And, you know, we didn't phone in our appearances, as apparently members of the GAB board did too, who apparently weren't really interested in reading in detail the complaints that were being made and monitoring what the staff did. That is not the way the FEC worked. In fact, I spent every day, all day, combing through multi-document investigations. And when we would have our hearings, where the staff would come before the 6 commissioners and make the arguments that an investigation should be opened, it frankly was like a Perry Mason episode, because the commissioners, including me, would cross-examine and really question the staff to make sure that there was real evidence of a possible violation. And even with that, we got a lot of work done. And yet, I think you've got severe problems here that need to be solved, both through the legislative and other process. Let me end with this, and I will then be happy to answer some questions. Look, everything I've talked about, this whole campaign finance area, this is a very complex area of the law. I can tell you right now that the federal election campaign finance laws are so complex and so Byzantine that there's only about 24 lawyers in the country that really understand how they work. Most of them live and work in Washington, with a couple of exceptions, and they make a fortune advising their clients on this Byzantine and very complex law. But all of this boils down to this, this idea and these rules. In the Citizens United case, there was a real possibility that the head of Citizens United could have been charged by the Justice Department with a knowing and intentional violation of the Federal Election Campaign Act and gone to prison for what? Making a political movie. And here in Wisconsin, you had individuals also who were being investigated and who could have gone to prison in a prosecution for what? For working on issues that they thought were important to them and to the state. Now, there might be some folks like the reporters at the Journal Sentinel who want to live in a country like that, but that is not the kind of country that I want to live in. So, thank you. So I'll be happy to answer any questions.
And if anybody has any questions, I will bring the mic around. That way we can get your question for our viewers listening in the audience. Are there any questions? We've got an expert here, campaign finance law. Representative Bernier.
We are currently working on Chapter 11 campaign finance rewrite. I was wondering if you would make yourself available to review that document before we are ready to let
I would be happy to do that, yes.
Other questions from the audience?
But well, let me say one thing about that, by the way. Okay. I'm always amazed when people say to me, oh, we're going to have a nonpartisan board running something. Okay. There are no nonpartisan boards. Okay. There are people who claim they're nonpartisan or they're non-interested. But it's just like, you know, there are a number of states that have set up so-called independent redistricting commissions. Okay, well, right now there's a huge lawsuit in Arizona over the Arizona Independent Redistricting Commission because the claim in the case, and you can read this in the court opinion, is that this supposedly independent redistricting commission seemed to, when it was drawing lines, favor one particular political party in what it was doing. Okay, now, I really think that boards, whether it's election boards, ethics boards, et cetera, my experience on the FEC and my experience on 2 different county voter registration election boards, one in Virginia and one in Georgia, is that the best situation you have is when you have representatives of both political parties there, and they're watching each other like hawks to make sure the law is followed and that that particular board does not engage in partisan activity. And the one thing you can say about the FEC now is that, look, there are 6 commissioners. It takes 4 votes to get anything done. So for the FEC to open an investigation, to target a candidate, target a political organization for investigation, both political parties have to agree that it's justified. And that is why, while you may hear criticism of the FEC, you know, some people think it doesn't do enough, you never hear anybody say that it engages in partisan witch hunts, which I don't think you can say about the Wisconsin GAB. But the reason for that is that you have members, commissioners, who there's no bar on you having been a member of a political party. And in fact, I found that having people on, as commissioners who were involved in politics and campaigns was a good thing, because they had a practical experience that I often found the staff didn't have. And so the staff didn't understand how some of these laws actually worked in practice, and sometimes they would come up with these crazy legal theories that were crazy. And having experienced political people there, that's the way these commissions should be run. And, you know, you make it even so that it takes so that one party can't dominate, and that way you're not going to get the kind of targeted political witch hunts that I think some agencies get if you try to supposedly have nonpartisan people on, and if you have an odd number board running things. It's probably more.
I agree with that, but the one different thing that we have in our state currently that maybe we didn't have is the incredible influence that staff had over that board.
Yeah.
And that board took and continues to take nearly every recommendation from staff without question. That is one of our major problems that we need to deal with.
Yeah, well, that's why you need to not have people who are retired and who phone in their parents there, okay? I mean, that's a very simple thing, but I tell you, it's very important. I would never approve a rule for a board where the board members don't actually have to appear in person for the meeting. They can just phone it in, because they don't pay attention to what's going on. You have to be in the office as a commissioner where you can read through the very extensive files before you go in and have a hearing and decide what to do about it. And putting somebody who's retired on, who's thinking about their really nice home down in Florida that they really want to get to, is not the way to have. You need an active, participatory membership on any kind of commission who is going to keep an eye on what the staff does and make sure that they're not going off on tangents that they shouldn't.
We have time for more questions. Let me bring the microphone over.
Just kind of going along with what you said, when you're on the FEC, is there an oversight entity that was monitoring your work and your decisions, that was legislatively connected? Did any of the Senate committees have any oversight?
No,
there was no oversight.
Well, actually, it was kind of interesting being a commissioner, because it was the one time in my entire life where I could vote the way I wanted to and make my own decision, and when anybody could do anything about it. Because the six commissioners, there's 3 Republicans, 3 Democrats. They are nominated by the president, confirmed by the Senate. And the way they're picked is, for example, with Barack Obama in the White House, you know, he can pick whoever he wants for the Democratic seats, but it's been a long tradition with the FEC that, for example, a Democratic president, in order to fill Republican seats, will go to the Republican leader in the House, the Republican leader in the Senate, and get the folks they want. And that's the people that he nominates. But once you're a commissioner, you all make your decisions. No one can reverse it unless somebody goes to court and they win, which people often win against the FEC. And frankly, when I was a commissioner, there were times when I was hoping people would win against the FEC. And other than that, there are two committees, one of the Senate, one of the House, that have oversight over the FEC in terms of its budget and so forth.
Okay, that's one of the key things. So
Yeah.
when you wanted to spend money, you had to go to legislators to get the money.
Oh, yeah.
And so there was oversight.
Our entire budget had to be approved by
Okay, there was
the
some
Senate and the
oversight
House.
then of, well, what are you spending
Yeah.
all this money on?
Now,
at that
this,
level.
This isn't a rule for the FEC, but it's something I would urge state legislatures to consider, because frankly, this is something that Congress ought to do, which is if you're going to have a state ethics agency that does this kind of work, and if they have the power to issue regulations, I would put into the bill that no regulation that they issue will be effective unless it's approved by the legislature.
Thank you. It would be a big improvement.
I mean, I think that ought to be done with the entire federal government.
Yeah, my question is there any federal law or rule that there cannot be any changes made between a primary and an election, changes to how we do our elections? Is there, like, let's say the primary happens in February and then we reconfigure GAB in March. Is there a rule or a law
No.
against doing that?
No, not that I'm aware of.
Okay.
Other questions?
I'm curious as to your thoughts on the future of campaign finance law in general. Obviously, there's been a lot of movement, Citizens United not being the only one, but you've been seeing the Supreme Court maybe take its the First Amendment a bit more seriously than they had even in the past. It strikes me that the appearance of corruption or the appearance of corruption in laws intended to further that effect would make 90 to 95% of the current campaign finance infrastructure completely illegitimate. I mean, even something as simple as a $2,700 maximum contribution to a presidential candidate in an age when you're spending, $750 million on a campaign strikes me as pretty difficult to justify a strong appearance of corruption for somebody who gives $2,701, for example. And I'm just curious what your thought is on where the law is moving and what are some of the hot button issues that you see moving through the courts down the line.
Right. Yeah, you all probably, I didn't mention it, but I mean, there was a very important case last year that came out after the Citizens United decision called FEC versus McCutcheon. And FEC versus McCutcheon, the Supreme Court did another, I think, good decision. And remember, I was talking about how in the 1970s, Congress, in addition to say you can only give $1,000 to a candidate, that by the way is now $2,600.
That just happens, apparently. Don't anybody panic. We've been through it 3 times already. They'll come in and say,
Hopefully it's not the heat of my rhetoric.
if not, move outside. Orderly.
Are they gonna come?
No, somebody is going out. They can hear it all over.
Oh, they can? Yeah.
I don't know if I keep talking, can you hear me? Yeah, okay. One of the best things that happened to the U.S. Supreme Court was when Justice O'Connor left and Justice Alito came on to because what happened was, O'Connor actually helped uphold the McCain-Feingold law in another case called FEC versus McConnell. And with her gone, Alito is just great on these issues. I like to say I was actually at the Justice Department when Justice Alito was nominated, and I was the person asked to brief him on voting, election, and campaign finance issues. So I'm hopeful that it's all because of the fact that I helped brief him on these issues. But whenever it comes to Justice Kennedy is bad on many issues, but on the First Amendment he's pretty good. And so there's been a whole series of decisions, including the last one, FEC versus McCutcheon, in which they threw out the aggregate limit. And what the court said was, the limit is, like I said, it's now up to $2,600. That's how much you can contribute to a federal candidate. But there was an aggregate limit. So in any one particular year, you couldn't contribute more than, I forget what the amount was, like $40-something thousand. And the court came back and said, it doesn't make any sense. if Congress said that contributing $2,600 is okay, you know, if you're $2,600 or under, there's no risk of corruption. Why does it matter? How is there some risk of corruption if you give $2,600 to 15 candidates, but suddenly you can't give $2,600 to 20 candidates because you go over the aggregate amount? So they said that that made no sense, and they tossed that out, which I think is a good thing. I don't know where else they're going to go with this. They pretty much have upheld the contribution limits. The one thing I would say about that is reformers are constantly talking about how you have to have contribution limits. But, you know, there are many states, Utah's one, where there are no contribution limits. You can contribute as much as you want to somebody running for state office. You got to report it. You got to disclose it. If you look at, I think it's Governing Magazine, Utah is regularly rated as one of the best-run state governments in the country. So the idea that you're suddenly going to have all this more corruption if you lift the campaign contribution amounts as opposed to other states, there's just no evidence of that, you know, whatsoever. So.
And unfortunately, our time has expired, but I want to have everybody give another round of applause to Hans von Spakovsky. He'll be sticking around if anybody has any future follow-up questions, and if you could please leave your name tags at the door on your way out. Thank you, everyone, for coming.
big transition. Bob, how are you? Good to see you. Thank you very much.
It is.